We flipped a coin to find out who was going to speak first, so that's how Charlie is going to start this off shortly. I'd like to say just a few words and let you know who he is. Charlie Fitzgerald, age 40, is a partner in Lafayette law firm of Cox and Fitzgerald, LLC. Charlie is a highly competent family lawyer, and also, more importantly, he is a devoted father to his wife, Jenny, and their 3 young children. The firm focuses exclusively on family law cases and has one purpose: to be of service. Charlie is a 1992 graduate of the Episcopal School of Acadiana. He earned a Bachelor of Science degree in microbiology from Louisiana State University in 1997. He received his JD degree in 2001 from Louisiana State University Paul M. Abreu Law Center, graduating to the top 5% of the class, Louisiana Law Review and Order of the COIF. Charlie was admitted to the bar in the state of Louisiana in 2001. Since that time, has been admitted practice before the U.S. Fifth Circuit Court of Appeals, U.S. District Court for the Eastern, Middle, Western District of Louisiana, U.S. Bankruptcy Court for the Western District of Louisiana. Charlie is a member of the Federal Appellate Bar Association, Federal Bar Association, Louisiana State Bar Association, Lafayette Bar Association, including the Paula K. Woodruff Family Law Section. He is also a member of the American Inn of Court of Acadiana. Since Cox Fitzgerald was founded in January 2003, Charlie has handled hundreds of law cases, family law cases, including everything from international adoption under the Hague Convention and the most complex custody and child support proceedings. Charlie is trained in collaborative law and has given presentation on various family law issues to the Society of Louisiana CPAs, the National Business Institute, and the Lafayette Bar Association. Prior to joining Cox Fitzgerald, Charlie was an assistant at the largest law firm in Louisiana, namely Jones Walker. Charlie and his wife, Jeannie Fuselier, a lifelong resident of Lafayette. They have been blessed with 3 young children: Patrick, age 3, John Henry, age 6, and Annalise, age 5. Charlie and Jeannie are also faithful members of St. Pius Catholic Church, and we're certainly happy to have you with us this evening.
Thank you, Mr. Baudouin. Thank you, Mr. Baudouin. Thank you, concerned citizens. What an honor to be here and to be able to speak in front of you. During this process, I've been asked, as you can imagine, who are you? Or what are you? The answer is pretty simple. 1, I'm a Christian. 2, I'm a husband. A teammate and wife of 10 years is sitting right back here. Her name is Jean. Jean, can you stand up? 3, I'm a father. We have 3 young kids. And so Patrick, age 8, John Henry, age 6, and Annalise, who's now 5, going on 40. It's Annalise, that as an aside, we were in front of Scott, in front of the city council, and I made a comment. I said that, I was introducing my children. I had them there with me, and I said, and this is Annalise. She's the boss. For 2 weeks after that at her house, she walked around, I'm the boss, I'm the boss, I'm the boss. It said that you live and learn as a parent. Lafayette is my home. It always has been. It's where I went to high school, at the Episcopal School of Acadiana. That after high school, I went to LSU. And by all things, that as a lawyer, my undergrad degree is actually in microbiology. It's a go figure. But it was that degree that was actually critically important for law school because it helped me think analytically. And so I went to stayed in Baton Rouge, went to LSU Law School, and I did. I graduated top 5% of my class. Was and this is just a bunch of legalese, but I was a member of the Louisiana Law Review, and I was also a member of the Order of the Coif, and those are both academic legal societies that your membership is based purely on performance. That after law school, I went to work for the biggest firm in the state, Jones Walker, okay, where I did corporate litigation. That for 2 years I was at Jones Walker, then I got engaged again to the love of my life, John, and that made a decision. You know what? It's time for me to go home. That my firm is Cox Fitzgerald. When I came home, my partner, Judge Ronnie Cox, and as an aside, Judge Ronnie Cox, he's one of the co-founders of our Lafayette Family Court. That Judge Ronnie Cox and I, we made a decision. From the time that Cox Fitzgerald was started, he was going to be exclusively a family law firm, meaning that we handled every family law type of case, from the divorces to the custody issues to the child support to the community property. That's what we do. That in fact, in going through essentially the cases, that I have been involved in 800 cases since since Cox Fitzgerald, since it was founded in 2003, either as lead attorney or as an attorney supervising a junior associate. I've mentored 5 attorneys in the field of family law. In addition to that, litigated everything from essentially international abductions in federal court under the Hague Convention to the most complicated community property cases, to the most complicated custody cases, to the most complicated child support cases. I'm frequently asked to lecture on family law. In fact, I just committed to lecture December 16th in Baton Rouge and 17th in Lafayette on community property issues, specifically complicated community property partitions. That I've been asked to lecture to the Society of Louisiana CPAs. Okay, the Society of Louisiana CPAs, it's the society of experts. These are experts. They have to get their own annual hours, and so they have to sit through what we call our continuing legal education hours. And so that was a tremendous honor for me to actually lecture to experts that we qualify in cases all the time on child support issues and also property issues. In terms of legal organizations, Mr. Beaudoin was kind enough to go through I guess some of the organizations and my legal affiliations. First, I'm collaboratively law trained. I've seen in doing this, in doing family law, you see enough pettiness. You see the waste. You see the waste of resources. You see the turmoil of the effect on children. Collaborative law is designed actually to avoid the legal process, to avoid the dispute-founded process, the litigious process, and to do it in a manner that's more by agreement and to keep cases out of the court system. In addition, I'm a member of the Acadian Inn of Court. And so that's a legal membership where people talk about, we're actually the members, that it's designed to promote that professionalism and honor between both bench and bar. That in addition to that, I'm qualified to practice in every federal court in the state. Okay, that's the eastern, western, and middle districts of Louisiana. In addition to that, I'm qualified to practice before the U.S. Federal Fifth Circuit. I'm also qualified to practice before the U.S. District Court, the Bankruptcy Court for the Western District of Louisiana. I've also practiced in terms of bars. I am a member of the Federal Appellate Bar Association. Also a member of the Federal Bar Association. Those are 2 separate bars. Also a member of the Louisiana State Bar Association, the Lafayette Bar Association, including its Paula Woodruff Family Law Section. In terms of legal experience, everything that I just went through, it pales in comparison to really why I'm qualified. Qualified because I'm a husband. Qualified because I'm a father. Okay, I'm running for family court judge. What is that? What is family court? That's a question I'm always asked. Family court, by definition, is divorces or cases involving minor children. In other words, these are the custody cases. Every case in front of the family court has a custody element. And so these, by way of example, it's the divorces with minor children. It is, before I had children, it was impossible for me to really understand children. I understand the complexities associated with being a husband. I certainly understand the complexities associated with being a parent. At my house, we have the 8 p.m., tonight I'm sure we're going to have it too. At 8 p.m. every night, we have the 8 o'clock standoff. What is the 8 o'clock standoff? You think it would be easy to get 3 kids in their PJs to say their prayers and to read maybe a bedtime story from 8 to 8:30. Easy, right? No. It's a 30-minute standoff. And so that you get every excuse in the book of why they shouldn't have to go to bed. You get the request for the chocolate milk. Not just chocolate milk, but 2 exact scoops of chocolate milk. I mean, not the liquid Hershey's, but the powdered Hershey's. On and on and on. And so that it really is a dynamic that if you have kids, you can empathize with in a millisecond. If you don't have kids, it's just a funny story. In terms of 10 hours later, usually it's 6:30, in between the hours of 6:30 and 7:30 in the morning, we then have the standoff for breakfast and to get the kids ready to go to school. Usually every morning one of them has a tummy ache, headache, leg ache, toe ache, ankle ache. I mean, you name the aches, they have it. That finding shoes, for example, I mean, that turns into the scavenger hunt of the day. In addition to that, I do understand what it's like to tell children no and to watch them speed walk to mom and say, well, daddy said yes. And you're speed walking right behind and say, well, no, I didn't, and try to explain. Those are things you can't learn in a textbook. And those are things, unless you understand essentially that what it is to actually be a parent 24 hours a day, 7 days a week, it's impossible to truly understand the subject matter before you as a family court judge, namely children. What have children taught me? Patience, selflessness. You're continuously acting on their best interest, not yours. Your needs all of a sudden become secondary. Your whole life becomes essentially devoted to your kids. It's also taught me essentially an ability and a willingness to stay in the struggle. Things get tough as a parent. Things get tough as a spouse. But you better have the fortitude to stay in there, to hang in there. You know what? As a parent, we do because it's worth it. Kids have also given me a profound understanding of unconditional love. Any parent, you give your life in a millisecond for your kids. That's something that until I had kids, I really didn't have any concept of that sort of love. I didn't realize that I could actually love to that degree. That my decision to run for judge, it was a team decision that I made with my wife after much thought, after much prayer. We know we're doing it for the right reasons. We know it's where God wants us to be. That we're committed to victory. That in fact, for my part, I've actually shut down my practice. That the signs you see around town, you're looking at the person who put all those up. In addition, I go to door every day. That if I haven't been to your house, you can book it. I'll be there before this election that happens on November 4th. That I also understand that I can't do it alone. That I would encourage each of you that on November 4th to please consider me for the next family court judge. Thank you for your time.
I might mention that we'll certainly entertain questions after Judge Susan Theall makes her presentation. So I'd appreciate, at that time that you come up to the mic and ask that question as opposed to shooting from the hip and asking, because we try to run the question through our filming of the program, and it comes out a whole lot better than what we'd appreciate doing that. Thank you. And our next speaker, of course, is biography on Judge Susan Theall. Judge Theall was sworn in as a judge on December 2nd, 2011, and is one of 2 family court judges in the 15th Judicial District. She was chosen by the fellow judges as Chief Judge of the district and began her term as Chief Judge January 2014. In the short time she has been a judge, she has started 2 innovative programs: Kids First, a substance use evaluation and treatment program for parents who is impaired, and self-represented docket for people who cannot afford legal representation. She was also chosen by Louisiana Supreme Court to participate in the 2012 Judicial Leadership Institute and be a domestic violence trainer for other judges in the state. Prior to becoming a judge, she concentrated her law practice and family for 26 years. In 1995, Judge Theall became one of the first lawyers to be certified as a family law specialist by the Louisiana Board of Legal Specialization. She is still certified as a family law specialist, but is on inactive duty because she's a judge. She was named Louisiana Supreme Lawyer in 2007, 8, 9, 10, and also in 2001. Judge Theall has been an active member of her community and has been actively involved with the Faith House, Lafayette Volunteer Lawyers, Louisiana Bar Foundation, and Lafayette Louisiana Bar Association. She has been a member of the Lafayette Youngsville Broussard Chamber of Commerce, Acadiana Republican Women Friends of Music, are an organization which raises funds for scholarships for UL music majors, and the Acadiana Symphony Women's League. She has taught courses in family law since 1995 for both her legal profession and various presentations sponsored by the Lafayette Commission for the Needs of Women and the League of Women Voters. Thank you, Ms.
Thank you. Good evening. Thank everyone for coming tonight. It's a pleasure to see a packed room. Sometimes when I come to Concerned Citizens, there are sparse attendance, and sometimes it's packed like tonight, and I think it's great to see all of you. I'm Judge Susan Theall. I start court every time I open court by saying I'm Judge Susan Theall, and it's an honor to serve you. And I want to tell you, since December the 2nd of 2011, it's been an honor to serve my community. This position is not about personal aggrandizement or doing something for yourself. It is about serving our community. Every elected official deep down inside, the reason they're doing that is to bring the talents that they have, that they've been given by God, to serve our community. And this is what I've done for the last 3 years. I've been a lawyer for 29 years. It kind of blows my mind. I'm just amazed that it's been that long. I practiced law for 26 years before being sworn in as a judge on December the 2nd of 2011. And so it's been a total of 29 years. I'm 57 years old. I've been in Lafayette. My family has been in Lafayette for 47 years. So I've grown up here. I've been a deep part of our community here. But let me tell you a little bit about what I've done as judge. It was a very exciting time to have the trust and vote of the people of this district, because it is a trust to be elected as family court judge. I started off with a bang. I was sworn in as soon as I could be, because the election was in November, and so only 2 weeks later I was sworn in as judge. In early 2012, the Louisiana Supreme Court chose me to be part of their Judicial Leadership Institute. And the Judicial Leadership Institute is kind of like Leadership Lafayette or Leadership Louisiana. And basically, the Supreme Court tried to identify judges with leadership qualities that they thought they could further train so that we could lead the courts forward. Part of a judge's job is to try to instill in the community faith and trust in our system of justice. We are supposed to be neutral, be impartial, judge a case only on the facts, not on who we know or who the lawyer is in front of us. And so that's part of what we learned through the Judicial Leadership Institute. After my training, I started thinking about some of the problems that we had in family court. When I ran in 2011, my vision for family court is that it was a place where people could be treated with dignity and respect, where matters could be handled more quickly. Because in high conflict cases, parents who have to wait a long time become more acrimonious. And so part of our job is to try to move cases through as quickly as possible. But what I focused on in May of 2012 is the continuing problem of substance use that I saw. In family court, before I was elected, if someone had a substance abuse problem, they were only given supervised visitation until they could show that they had had a year's worth of clean drug tests. The problem with that program is that many parents fell off the face of the earth. It was an insurmountable problem to them. They didn't have the family support. They didn't have anyone telling them where to get treatment. They didn't know what to do. And oftentimes they threw their hands up in despair and they dropped out of their children's lives. And that's not good for children. So I interviewed a number of different drug treatment providers between January and May. And we finally settled on a company called Clear Start LLC. And we devised a program that's unique in family court. And in fact, judges from around the state are asking, hey, what's Theall doing over there in Lafayette with that drug program? It's worked really, really well. We've run, in fact, My assistant, Stephanie Van Fleet, is here with me tonight. She and I ran it out of my office for the first 2 years because we wanted to try it, and I think outside of the box sometimes, and I try to come up with solutions, and the other judges saw that the program was really working. And so in June of this year, we were able to obtain a sum of money to hire a coordinator, so Ms. Van Fleet no longer had to run the program. But we actually had 300 people go through the program. Some were great success stories. One little boy told his mama, "I'm so glad I have my daddy back." One woman who was a nurse and had lost her nursing license because she refused to acknowledge that she had problems, was evaluated through the program and finally came to sobriety by acknowledging that she had a problem with drugs. And she's now clean, and she's been clean for almost 2 years. So we have had some successes. Unfortunately, we've had some parents who failed. And I tell them, if you fail, it's okay. I'm not here to judge you. I want you to get back up on the wagon again and try again, because your children need you, but they need you sober. When we first started the program, we focused just on drugs, either abuse of prescription drugs or illegal drugs. And we're not talking about mild stuff, y'all. We're talking about smoking crystal meth. I mean, it just kind of blew my mind. I couldn't believe what's out there in our community. But we saw children who were just really being harmed by their parents' behavior. One day in court, there were 2 lawyers who asked me to talk to a 12-year-old girl, and I don't like talking to children. Usually I ask the parents about health insurance, that we can get the child to a counselor, and the counselor can be the child's voice, because I think children should be kept out of their parents' acrimony and their parents' fight. But this particular couple was poor. They had no health insurance. There was no mental health counseling, and so I finally capitulated, and I talked to the 12-year-old. And her grades were A's and B's, and had dropped to C's and D's. She normally had almost a perfect attendance, and her attendance, she missed 12 days or was late 12 days in one semester. And I said, "Baby, what's going on?" "Oh, nothing, Judge." So, we talk a little while, and finally I say, "Baby, look, the grown-ups have to make decisions for you. And your mom and dad are pretty mad at each other, and they can't make the decision, so they've trusted me to try to help them figure out what to do. So you really have to tell me what's going on." And finally she said, "Judge, my mom is so depressed, and she gets so drunk every night that she passes out, and I can't go to school the next morning until I know if she's alive. And sometimes if I know she's alive, I need to stay home and take care of her." So when I heard that, I realized that we needed to add in alcohol to our substance abuse program, and so we have done that. The good news is that most parents are responsive. They're angry at first, but they're responsive because they love their children. And so how do we do this? We get them evaluated. We try to get them into treatment if they don't have money. The providers that we have are able to find them free treatment in state programs. And what it's all about is trying to get the parents safe and sober so that they can take care of their children's needs. Studies show, and evidence in court shows, that parents who are drunk every night and passed out, parents who are using drugs, are the parents that aren't making sure that their children get their homework done. They're the ones that aren't making sure that their kids get to school on time. They're the ones that don't put their kids in extracurricular activities. So the program has great merit, and I'm really proud of it. The exciting thing for me, too, is that now that we have a coordinator is taking the program to the next level, because there was an extent to what Stephanie and I could do in my office. So the coordinator has just been trained on something called the TCU instrument, and it's just Texas Christian University, and it is a psychological questionnaire as well as a questionnaire to determine whether there's going to be any criminal acts. The psychological portion of it is really important and exciting to me, because we're going to be able to pinpoint where the issues arise. Most people who have drug or alcohol issues have mental health issues, pure and simple. My hope is to eventually have everyone who files a petition for divorce go through this screening instrument so that we can find out from the get-go which of the cases tend to be high conflict so that we can try to address those needs. One way to address high conflict cases is through resolving things as quickly as we can. But the other way is to also find out if there are mental health issues or do psychological evaluations. Most people can't afford that. We are a very wealthy community, but we have a large unserved portion of our community and a very high poverty level. You don't really see it, and we're not really always aware of it, but I can tell you in family court we're aware of it. So I've also been appointed by the Louisiana Supreme Court to be a domestic violence trainer. That means, and in fact, Judge Blanchette, the other family court judge, was also chosen by the Supreme Court to be a DV trainer. What that means is that the plan is for us eventually to go out to other parts of the state and sometimes into other states to train other judges on domestic violence and how to handle those cases. We're going to try to take it a step further, and we're also going to try to meet with our local law enforcement officers because some of the law enforcement officers still don't understand domestic violence, and so we want to give them additional training so that they know how to handle it. I talked a few seconds ago about the great disparity in wealth in our community. Very, very wealthy and very, very poor. On Thursdays, we have what's called our rule docket, and there are generally about 50 matters set in my courtroom. So that means, mom and dad, that's 100 people right there, and there's witnesses, and my little courtroom is packed. Invariably, when you're sitting on the bench, you can see the people who are by themselves and who are afraid. There are more and more people who cannot afford lawyers and who are there trying to represent themselves. At some point in 2012, it became glaringly apparent to me that we had to do something. Because I would call the people up, I would shake their hands were sweaty and wet, they were shaking most of the times, and they said, "I don't know what to do, Judge." And I'd say, "Okay, well look, can you wait until noon? When I take a break for lunch, if y'all come meet with me in my office, we'll try to figure out what the problem is and we'll see if we can solve it." And invariably that worked. I've had training as a mediator, but also I've had 29 years of experience in family law, and the people that came without lawyers are just like anyone else. They had custody issues, they had child support issues, and really they just needed someone to break the impasse. Because what was happening, they didn't have custody judgments, and so if the child went to visit dad for a weekend and dad got mad at mom, he would keep the child. And then mom would call the police, then the police would come, and the kids were scared. So what we're trying to do is keep kids from getting scared and trying to give them a custody judgment so that they know when the child is going to be visiting. So as I saw increased numbers of people in the courtroom without lawyers, I started what's called my self-represented docket. And it is for people who cannot afford lawyers. Most of the people that are in the self-represented docket can't even afford to drive. They don't own cars. I can remember telling one lady, well, you can go XYZ, and she said, "Judge, I had to pay someone to drop me off at the courthouse." And I said, "What do you mean you had to pay someone?" She said, "Well, I don't have a car. I didn't know how I was going to get here." So the people that we're talking about are people who have nothing. And they have needs just like everyone else does. So my self-represented docket is a once-a-month docket. I limit it to 25 people because there's just a limit to what you can do. I swear the parties in, I ask them what their problems are, and then we try to solve them. When I first started, the Supreme Court has what's called a self-represented parties committee, And that committee gave guidelines for judges to follow. And I will tell you, it was 2 pages of gobbledygook, legal gobbledygook. So the first day I did this self-represented docket. I tried to read it and tried to go through it, and they go, "Huh, Judge, what you mean?" They didn't have a clue. The words were too big. I said, well, this is because the Supreme Court's word is self-represented litigants. What's that litigant, Judge? What's that? I mean, they didn't understand half of what I was saying. And so then it evolved to where I'd say, okay, sir, you filed a petition for custody. Can you tell me why? But he was so afraid he couldn't say anything. So it evolved to swearing both of the parties in and saying, sir, I can see you filed a petition for custody. Tell me what's going on. You've got to keep it at a real simple level so that people can understand, and there's no need to make them afraid, because I'm there to try to help them solve the problems. And generally it is things just like everyone else has. It is custody, where's the child going to live, where's the child going to go to school, and who's going to pay child support. So I'm proud of the program. I've had judges from around the state come and observe. And I had one judge from New Orleans say, well, I don't know if I can do it the way you do. And I said, then you don't have to. Everyone has their own style. Everyone has their own strength. I just saw a need, and this is the way that I saw to fill that need, or to fix that. And so it's been, for me, one of the most fulfilling things that I do, because I'm actually doing what I went to law school for, which is to help people and to really make sure that parents focus on their kids. Also, as a judge, I'll tell you, it's been so interesting because parents are so angry when they come to court, and we don't have intact families in family court. We have people who are divorcing, or we have people who have never married, and are simply so angry with each other that they can't focus on their children. So I tell them all the time, you know, I'm so surprised to see you here today. And they look at me like I'm crazy. And I'll say, yeah, it means that you're so mad at each other that you're going to let a stranger decide where your children are going to live. And sometimes they're startled and they shake their head, and I think it's the first time they actually thought about it. And sometimes they say, Judge, can we talk? And I'll say, yeah, go use my conference room. Please go talk. Sometimes they can resolve their problems. Many other times they are so locked in anger and in battle that they can't see straight. They can't think of their children. And so that's what we do in family court. We evaluate evidence that's in the courtroom without regard to who you are, who you know, or who you're represented by. And we look at what's in children's best interest. As a lawyer, I'll just say, I practiced law for 26 years before becoming elected. I'm a board-certified family law specialist. I've been a specialist since 1995, since the specialization was first offered in the state of Louisiana. I'm very proud of that specialization. It says that I've devoted my professional career to family law. And to say that I can't do a good job because I don't have children diminishes who I am as a person. I have interacted with psychologists and with thousands of parents and children. I am 57 years old, and I have done this area of law exclusively for 29 years, and I will tell you, I know what I'm doing. I love what I'm doing. I've devoted my career to family law. The very first case that I tried as a lawyer was a custody case, and I saw the impact that my work could have on a child, and that started me on my journey to doing family law exclusively ever since then. I've been actively involved in our community and will continue to be actively involved in our community. I've been a member of the Lafayette-Broussard Youngsville Chamber of Commerce because I believe that we have to be a part of the organizations and we have to be part of the community that we serve. Because remember, this is a position of public service. I've been on the board of directors of Faith House. I served as a board member for 3 years. I've been a board member on the Louisiana Bar Foundation. The Louisiana Bar Foundation is an organization of lawyers who are promoting faith in our system of justice. And we also give grants. We use the Interest on Lawyers Trust account to provide grants to the community. Before I became a member of the big bar, the Louisiana Bar Foundation, I was a member of the Acadiana Community Partnership Panel for years, giving grants money to different local organizations for seed money to try to improve our community. I was also the chairman of Lafayette Volunteer Lawyers back in the 90s, probably 96 or so. I've donated countless pro bono hours, and for those of y'all who don't know what the word pro bono means, it means free legal services, to try to help those who are less fortunate in our community. I was recognized by the Louisiana State Bar Association as the Pro Bono Lawyer of the Year in 1996. Paula Woodruff and I practiced law together before she died in 1998. I was one of the group of lawyers who started the family law section, and we ultimately ended up naming the section after her because she was probably the best family law attorney in Lafayette. So I've been deeply involved in our community. I want to continue to serve our community. This is a position of public service. I believe that I've got the skills, the character, the knowledge, the integrity to continue to serve our community. And I ask you on November the 4th to allow me to continue to serve our community. Thank you.
Thank you, Judge. We'll entertain a question, if you will. Mr. Bob Love.
I'll get there.
I've been here a while, and you've been here a while longer.
We are very fortunate to live in a community that has two people as qualified as these two are to serve in our community. Regardless of who wins, the person who comes in second can be proud that they achieved recognition in Lafayette, and there will be a future for them. My question is this. There's a lack of discipline in our community. On the highways, people dodge in front of you. In the classrooms, there are students who get up and who use bad language and physically assault the teacher, 14, 15-year-old kids. And our classrooms have 25 or 26 kids in there, 25 of whom want to learn something and get ahead in the world, and one who's a renegade, who doesn't give a hoot. He's been punished and he doesn't care about what he's going to do, and he just creates a problem for the classroom. I would like to ask both of these two candidates if, in a situation where a neighbor saw a next-door neighbor punishing a classroom, a 10-year-old, 12-year-old kid, and they use a paddle or the switch or whatever, but the kid's being punished. And the neighbor calls and has the police come out because the kid is being attacked. Now, none of us here in this room believe in violence for kids. We don't believe in beating a kid, but there is a discipline that we must maintain. I remember when I came along, y'all don't remember that far back over there, but I remember that if I hadn't got lashings from my principal and for 3 or 4 teachers and had problems over there, that I might have burnt the schoolhouse down, who knows? But anyway, I'd like to ask these two people what their reaction would be if they had a person come into their courtroom because of paddling or punishing a child for a disciplinary problem. I really would like to have that. Can I?
I believe you start first. We'll start alternating back. So, Judge, you're first to start on the question.
There's a lack of discipline in society in general, and we see it in the courtrooms also, unfortunately. I've had to threaten to sanction lawyers because they interrupt each other or they're late to court. So I'm aware of the problems. I will tell you that there are many cases that are brought by the police to the Department of Children and Family Services where there has been paddling. If the marks are severe enough, generally we would sign an ex parte order, an immediate order transferring custody. So that's the kind of thing that we see in family court. We don't see discipline in family court. But again, to address the lack of discipline in society in general, that's part of the judge's job, is to enforce discipline in the courtroom because it's as big a problem in the courtroom as it is in society.
I'm going to go ahead and disagree a little bit that as a family court judge, you absolutely deal with discipline of children in cases in front of you. In fact, that's one of the essential elements, I mean, in any custody case. What is too much, that the facts that Mr. Lowe described, that if they're, usually those cases would come before you in the nature of what we call a protective order. And so then what is a protective order? When should it issue? Under law, when that battery or the spanking arises to a criminal. And so when it goes beyond essentially disciplining. That in terms of going back to essentially discipline, that I absolutely believe that what we're seeing in society is what happens when you remove God from everything, or you attempt to. That, and I'll also tell you that when I was a child, guess what? I got spanked. And so my personal beliefs, I'll go a little bit further. That I do believe that there's a difference between spanking a child for safety. For example, if they're getting ready to run out the road, when they're 3, 4 years old, they don't know any better, versus spanking just to spank. That when it comes to safety, that spanking on the tush, you know what? If it means protecting the kids, you betcha. Okay, that in terms of the normal context, I strongly believe as a parent, timeouts work better. And so that, but that again, going back to society, lack of manners, lack of professionalism, one reason why I'm running, it's to restore dignity to this division.
Thank you, Charlie. Right.
Thank you. I'm happy to say that both the candidates agree with me that they think it's a good idea for all elected officials to have to take a basic constitutional quiz to run for public office. So we've made some headway. It's strange that this subject came up so quick, and especially since you're family court judges, candidates. The issue in Dallas came up recently where a judge, family court judge, I understand, has refused to perform heterosexual marriages. What are you going to do if you should have that situation come up in your courtroom? How do you feel about that? Homosexual. No. Normal marriages, we'll put it that way. She will only perform ceremonies for homosexuals, for gay marriages. So I'd like to have that. Plus, there's one more. It seems like this hinges on discretion. I'm concerned about discretion because it seems like in this day and age, a judge can do any darn thing they want to do and they call it discretion. That's disgusting to me. And then the third question is, I have been in some courtrooms myself where I've actually heard judges say that if you mention the Constitution again, I'm going to hold you for contempt. How in God's name can this be when all of you have to raise your hand and swear to God to uphold that Constitution? How can any jurisdiction in Louisiana say that you better not use the word Constitution in my courtroom? Thank you.
You may have to leave your question up.
Right.
Ray, why don't you leave your question up?
You can't read that. Okay, first question. Same-sex marriage bill. What are you going to do if you good? Want to go first, Charlie? Sure.
Can everybody hear me? I think last time that I was talking, some people in the back were saying that they couldn't hear. So I can be as loud as anybody. the U.S. Constitution, it's an issue that's near and dear to my heart. I actually keep a pocket Constitution right on the side of my desk that I wish we could force all public officials to take a review course or a summary course on the interpretation of the United States Constitution. That I'll tell you, most people when they're asked how many amendments are there to the U.S. Constitution, they're not 27, there's 30. 3 of which have not been ratified by the 50 states. And so that's a little, I mean, that I didn't know this question was going to be asked, but I mean, that the U.S. Constitution is an issue that I know in depth. And I'll also tell you that essentially, if there's any ambiguity in the U.S. Constitution, all you have to do is look at the Federalist Papers, which are the documents upon which that instrument was written, and the intent of the document is spelled out with specificity. Second question, whether or not that if elected judge, if I would perform gay marriages or heterosexual marriages, that if I'm elected, I've got to take an oath. And the oath is to uphold not only the U.S. Constitution, but also the Louisiana Constitution and the laws of the state. It's against the law of Louisiana, I mean, for a celebrant to entertain a marriage between same-sex couples. So my answer is I could not. That in terms of discretion, this is also an issue that I know intimately. A big part of my practice was actually an appellate practice. That when you're talking about family court, you're talking about the term discretion. What you're talking about, it's appellate levels of review. In other words, if a judge makes a finding of fact, well, what is that? Finding of fact would be what's in the best interest of a minor child. Okay, should dad be the domiciliary parent? Should mom be the domiciliary parent? What's a fair amount, or what's a reasonable amount of child support? All of those are findings of fact. They're subject, when they go on appeal, the standard of review is abuse of discretion. Very, very high, very difficult to overcome. That I believe essentially that one way, and I think the question is not so much a technical, well, for appellate purposes, it has to do with explanations. When I represented clients, that I had one client in the history of my practice that did not follow my advice, and I fired him. It's because I took the time to explain to all my clients not just why I was advising that way, but why. And I would walk them through it. And I didn't care if it took 3 hours every week. That in part of this judicial campaign, where it's been so humbling to me, is that the biggest supporters, or one of the biggest groups of supporters that I have, it's my former clients. They don't have to donate any money to me. I mean, they've already paid me for my services. And so but in terms of discretion as a judge, as a judge, this goes back into having kids, learning patience. That you sit there and you should be able to tell whenever people don't understand something. And when you make a ruling, you explain it and you give reasons that are detailed, plain, and simple. Constitution, the use of the word, I think any judge that would say you can't use that term, I would love to hear some context. I mean, I think that's it probably grounds to recuse the judge right there. Just on the fact that you can't use the term. That of course you can use the term, assuming that the legal argument, if it has been properly pleaded before the court. Thank you.
Always have a good. No.
Here we go.
This is really easy, y'all. Same-sex marriage, you can't perform it. It's illegal in Louisiana. I will tell you, though, the most fun thing that I do as a judge is perform adoptions and perform marriages. But unfortunately, Ray, that's not something that you can test us on because it's not legal in Louisiana. Abuse of discretion, judges, every judge that I know wants to do a good job. They're proud of what they do, and they want to do a good job. They make good findings of fact. They make credibility determinations. And yes, there is some discretion in involved in that because we all hear things differently, Ray.
You know any in Washington?
No, I don't. No, I don't. No, I don't. And insofar as the Constitution is rarely raised in family court. Although there is one case currently that was decided by Judge Rubin in an adoption case. I believe you may have read about that recently. But that sort of thing was not in a family court. It was assigned randomly to one of the judges, and it ended up with Judge Rubin. So there's your quick and short answer to that very complicated question.
Larry? Well, y'all are ducking around all the important questions. Number one, who's your parents? Where do you live? Can you make a route?
All right. My mama is over there. She's Doris Landry Theall originally from St. Martinville in Broussard, Louisiana. My father, Francis Theall, died when I was 15. However, my brother Michael is here. Raise your hand, Mike. My nephew Tori is here. Buddy Guidry is here. My cousin Betty in the back. Raise your hand. Bruce, her husband. Oh yeah, I'm packing the court. Uncle Jesse, Aunt Pat. I mean, I got a lot of family here. So I was born in Jennings, Louisiana, but moved here in 1967. So our family is from Lafayette. So that was who's your mama? Where do you live? Where do I live? I live here in Lafayette. And can I make a roux? Let me tell you what, the last time I made a roux, my gumbo was so bad, I swear I'd never do it again. I'm just not a good, anyone that knows me knows that I'm not a good cook, and so I have to buy my own roux. Mama, you should have taught me how to cook.
This is the important question. My mother is Ann Dupree. My stepfather is Gene Dupree. That my father is David Sterling. He goes by quote unquote Terry Fitzgerald Jr. So Terry Fitzgerald, and my stepmom is Ann Fitzgerald. That they would have been here. That we would have had a lot of our supporters, but for the fact when they called, we actually told them not to come, and it was my mistake. It was my understanding that this was a closed meeting for really the concerned citizens. So out of respect for the group, we asked them not to be here. That said, that in terms of where do you live, I live at 208 Acacia Drive in Lafayette, Louisiana. That can I rule? You better believe I can make a decision. Can I make a roux? No, I cannot. The whole I
can. Is there another question? Yes, sir. Come on up.
With a last name like mine, I don't do roux, I don't do anything other than eat. I have a question, and I've gone back through and looked at the qualifications and such, and this is my question to you, sir. You talked about being a father and a husband and having children. I didn't see a lot of specialized training on your card or on your qualifications, and they may be. I listened to what you talked about. You were members of a number of organizations and such. You've practiced law. But part of that, as was commented by both of you, is that you look at counselors, there's a lot of elements that come into this. The parents themselves, the children, because the parents have problems, then that spills over into the children. So you have specialized training that I don't see on your qualifications. And so I guess what I'm saying is, how does simply being the father, the dad, the husband and such, not coupled with that training, make you qualified? That's the first question. And the second question is, what do you plan to do as family court judge if you're elected? I've heard the programs that, and this really is for both of you. Yours would be, you've heard what's in existence now. What are your plans for that? And yours is, you have plans now. What are your plans for the future? Thank you.
Thank you, sir.
For this position, that I would say I'm as qualified as any candidate has ever been that going into this election. That again, for the past 11 years, my firm Cox Fitzgerald, we've done nothing but family law cases. Again, I've been involved since the inception of the firm, that's January 2003, in over 800 family law cases, whether as the lead attorney or essentially a mentor that as a senior attorney supervising junior associates. I've mentored 5 attorneys that in the field of family law during my tenure at Cox Fitzgerald. That I've worked hand in hand with my partner for 11 years, Judge Ronnie Cox, who founded the family court. That I'm collaboratively law trained. In addition to that, that I'm again certified to practice in every federal court in the state. That I've handled international abduction cases under the Hague Convention, which very few family law attorneys ever even, they really rarely even hear about the Hague Convention. That in that case, in that Hague Convention case, the federal court judge, in awarding me $15,500 in attorney's fees, specifically noted my years of experience and expertise in the field of family court. In terms of what do I plan to do if elected, well, I'll tell you what I plan to do. Item number 1, it's to remove a glass partition that was put up after December or after the election in 2011. It used to be when you need to go talk to the judicial secretary, you could walk up to the door. That's not the case anymore. There's a glass partition where you have to cup your hands, turn your head, and then to say that that hey, I'm here or whatever to get the attention of the legal secretary. In addition, what would I do next? I would do away with the Monday pro se docket. Anybody that handles these cases knows that the biggest complaint by the people you represent is it takes forever to get the case to trial. There are some cases that have to be tried. And you know what? As a judge, that's what you get paid for. You get paid, you don't get paid to hear the cases where the people get along. You don't get paid to hear the cases where there's a consent judgment. Parties have already agreed to those cases. You're there for actually the contested cases. When you take a Monday trial date, and that's what it does, you take a Monday and all of a sudden you take the pro se litigants and you remove them to that Monday, you're taking away trial dockets. There's no reason to distinguish between pro se litigants and litigants that pay for attorneys. Absolutely no reason. In addition to that, I'm going to eliminate effective immediately what has become a policy of identifying preferred attorneys in open court as gold star attorneys, and in some cases giving out gold stars. That policy never should have began, and it will be eliminated effective immediately.
Well, let me address it very quickly. Mr. Fitzgerald is very distressed because I didn't give him a gold star. In fact, made a complaint and has complained because he didn't get one and his partner got one. The gold stars started as a very innocuous attempt to honor lawyers who were consistently on time, who got their briefs prepared, who got their judgments on time. Mr. Fitzgerald was not one of those. In fact, he showed up in court at 10:30 one time, half an hour late, and I had to get his associate in court, so he would not qualify for gold stars. However, because Mr. Fitzgerald complained about not getting a gold star because he thought it was so unfair, I have quit recognizing lawyers who have done extra well, and I simply say, thank you for your professionalism. Thank you for getting your judgment in on time, and thank you for getting your brief in on time, and thank you for being in court on time. But I don't give gold stars anymore, Mr. Fitzgerald, because you complained. As to the partition, there is a partition in my office because lawyers regularly try to have ex parte communications with the judge's secretary and try to have ex parte communications with the judge. There were some serious problems in family court where people continually talked to judges and tried to influence a judge outside of the courtroom instead of letting a judge base their judgment only on the evidence and the facts in court. And so in order to stop what had just run amok, we did put a partition, and there is now a doorbell, and so if there's someone that legitimately has business, we attend to it. But oftentimes, lawyers just are trying to have conversations with my assistant, Ms. Van Fleet, in the hopes that they are going to influence me. And that's not how things are done. It's how things used to be done. And in fact, I have not allowed Mr. Fitzgerald or Mr. Cox back, and they're not happy about it. But we try to establish a barrier so that in fact it is fair and impartial, because one thing that I heard continuously on the campaign trail 3 years ago is that people were tired of favorites being played. People were tired of names being dropped. People were tired of feeling that our system of justice was unfair. And it's my job as a judge to let you know that this is a fair system of justice. I am not going to be swayed by who you are, who your lawyer is, or who you know. I'm going to judge a case purely on the facts and evidence. Now, as for my plans for the future, we are now implementing one of the plans, which is to try to start screening for mental health issues all families who come into family court. We're doing it in conjunction with our drug program, but we are going to try to move that to have everyone who is filing a petition in family court screened so that we can find out if there are some real serious mental health problems. I had something on the tip of my tongue I wanted to talk about, and I drew a blank. It happens sometimes. That's the primary thing. Oh, we've also considered mediation. We have currently hearing officers. All of the hearing officers are trained now as mediators. However, there is such a backlog of cases. There are 860 cases on average a year assigned to my division just in Lafayette. Now, the 15th Judicial District Court is a 3-parish area. It's Vermilion Parish, Acadia Parish, and Lafayette Parish. So I'm not in Lafayette every day, Mr. Fitzgerald, but I will tell you I'm in court 4 days a week. There are times that I'm also in court on Fridays, but I have to spend time in Crowley, because that's part of my district. I have to spend time in Abbeville because that's part of my district. Fridays are generally for pretrial conferences. I start court on time, and that was one thing I pledged to do, because judges typically have people in pretrial conferences till 4 in the afternoon, and they're paying their lawyers to sit around and wait. So I require lawyers to have pretrial conferences before court starts at 10 o'clock, and I've gotten there as early as 7:30 in the morning. But I also pre-try cases after I finish in Acadia Parish. You know, I'll rush back to Lafayette and I'll have a conference. So for those of you who've had them at 4 in the afternoon, it's because I've been in court in Crowley. I have generally pre-trial conferences on Friday mornings for either the trials that are set on Monday or for the trials that are set for the next Thursday. So we're in court constantly. There are no days where we're playing. And to say that you would abolish a self-represented docket where it's 12 days out of the year to help people who can't afford lawyers and who need their issues taken care of just like everyone else makes no sense to me.
Mr. Fitzgerald said that he would abolish certain things, and I want to give him an opportunity, fair opportunity.
Okay.
My question was, you're looking at 4 years, okay?
Can you go to the podium, please?
I'm sorry.
6 years.
I can't read your lips.
6 years. You're looking at extended period of time. We're talking about a number of years. What you described in terms of what your actions would be were actions that I would think would take place within the first month. What I'm looking for, because I've got friends that have children involved in this, and people that I know that get involved in terms of having problems with going through divorces and such. What are your plans for the next 4 to 6 years for the family court? What projects, what programs, if any, are you going to implement? And if you, with some some of the specifics with regard to this. Because when you're elected, you're going to move in, and I would think that you would have a plan of what you're going to do for the next 4, 5, 6 years. That's the follow-up of the question. I wanted to give you an opportunity to cover the whole thing, not just the front end of it, okay? Thank you.
Before I respond, let me just touch on 2 quick issues that I did complain in open court about Gold Star favoritism because it's wrong. Plain and simple. That by definition, you do not show bias. Whenever you're in open court as a judge and you're referring to certain attorneys as Gold Star attorneys and others not, you better believe I spoke up in open court. That in terms of being late, I've never been late to any court proceeding without giving advance notice to the court. There are times when I have 2 cases, I've actually tried cases in one parish, like Iberia Parish, had an associate fill in, like the instance in question that Ms. Thale brought up. That whenever I return to court, that my associate handled. Again, I have never been late to any court proceeding in front of any court. In terms of going back to the question that according to our Supreme Court, in the family law cases, okay, that in every case you deal with minor children, so every case is a custody element. A judge is a fiduciary, stands as a fiduciary to those children. Your job is to protect those minor children. What are my plans? It's to protect the children each and every time when they come in front of me.
Specific stuff. How? That's what I'm trying to find out, is how.
How depends on the facts of every case. In terms of custody cases in particular, every case, by the reason we talked a little bit about abuse of discretion, it's because every case is fact specific.
I agree with you, but what I'm saying is there's no other plan under the say that I'm going to follow these guidelines and that's it.
I'm taking an oath, and in every word that I promise that I'll do, I will do. That I am uniquely qualified, for this position, that I intend to fully, that fulfill my duties.
I'll accept your answer.
Thank you.
Is there another question? I think we're a little over now.
Sorry.
But we'll take a question.
I want to say something.
You have a question, Ms. Dodd?
Microphone. Okay, my name is Dorothy, and we hear about judges, and I appreciate everybody who's here. I have a question for Ray. He's always given us questions about the Constitution. What happens tomorrow, Ray?
What happens tomorrow?
The first Tuesday of October.
City council meeting.
Supreme Court sits. And we're talking about judges.
Hey,
We're talking about the judicial part of
the
our country. It's just to put a little light.
Gotta start out.
First Tuesday of October.
She's just trying to keep you on your toes, Ray, as well. Yes, ma'am, come on up, please.
My question is directed to Mr. Fitzgerald. I'm Catherine Hurst. I'm an attorney in Lafayette. I have devoted my entire career to children and children's advocacy. First, I was a preschool teacher during school. Then I was a church youth director. Then I worked with sexually abused children at the children's shelter. Then I went to law school, worked for child protection as a lawyer, have spent my entire career doing child custody litigation. Are you telling me by what you said tonight that I don't know anything about children, even though I've spent my whole life on it, and you would be more qualified than me because you have children and I don't? I would like to add to that, virtually every woman lawyer in this district who practices child custody litigation don't have children of their own, because at some point in our careers we had to make a choice. I couldn't be the mother I wanted to be and do what I wanted to do. You have a spouse to do that. Are you more qualified to do child custody litigation than me because your wife bore children?
I think what I was saying, that in terms of, from my experience with children, I didn't know much about children until I became a parent, until it became a 24-hour job that all of a sudden superseded everything else. That it is a job that there are no times to clock out. That when we go home tonight, essentially, it's going to take a joint effort between me and my wife, that for an hour, probably an hour, to get our kids ready to go to sleep. And that, and again, we talked about that when we wake up, that we're there, and that we're there to actually have that struggle again to get them ready to go to school. If they get, well, I'm going to answer it if you'll allow me the time. If one of them gets sick during the night, we're the ones that stay up with them. We're the ones that day in, day out are there. And what it does give a unique perspective. And I do believe that if you're a family court judge, it is necessary to understand the struggles and the complexities of the people and the cases, in this case kids, that come in front of you.
So that does make you more qualified than every woman. Is that what you're saying?
He's already answered the question. You had the question, so. We have time for one more question. Don?
I had one question on
We have a brand new face here, so let's give her a shot. By the way, it's a pretty face.
No. Hi, I'm Ella Arsamoah. I just have one question. And you did say that there's a lot of programs in place for drug abusers and stuff. I'm just curious, are these people required to take parenting courses or anger management courses? For both questions for both of you. And if it's not, would you consider implementing those? And if you're a judge, would you consider implementing those if they're not?
Thank you, Ellen.
Both of those are currently out there and available. The family tree, the family tree transparenting class is required of anyone who has filed a petition and is going to deal with custody issues, number one. When someone is convicted of a domestic violence issue in our protective order court with either one of the hearing officers or after an objection, it comes before us. We do require that they go through a 12-week program. There is currently no quote-unquote anger management required. In certain situations that may be necessary, and it may be something that we can take advantage of. I will tell you that Lafayette has numerous programs available, some at no cost. There's one called Best Dads that is free and that is offered through the family tree, and we've often required some dads to attend that class. So we do what we can with the resources that we have. We also recognize that there are some people that can't even afford the $50 to go through some of these classes. So we try to place them with different free programs in the city. There are some offered through the Extra Mile. There are some offered through the Sheriff's Department programs. Part of the problem is that we don't have a family court administrator that can look for all of these programs and help us track it. So in the future, that would be something that we would need because there is a tremendous need. The need is to try to train people to be good parents because many people that we see in family court have not been properly parented themselves. And so what we're trying to do is actually steer them in the right direction, help them to recognize that they have to focus on their kids and that their children's needs come first.
In terms of mandatory classes that parents should take, that I don't, out of the gate, I don't believe there should be any mandatory class just because somebody files a petition for divorce. And what I mean by that, that if custody, if that does become disputed, then there is currently a mandatory class that both parents have to take. That we heard a little bit earlier, I guess, about one potential future plan, and that would be about psychological testing for anybody that files for divorce. I think that that's pretty dangerous, that to have people submit costly and dangerous, to have everybody who files a petition for divorce actually take psychological testing to predict whether they may be a danger to a child or may be an alcoholic, because you're talking about people that are apprehensive, scared, automatically sitting down to submit to a test, and that unless they understand, I guess, the scope of it, and unless you have a clinical child psychologist on staff that's going to be there to interpret those things, it's a scary proposition, and that's not what I would like to see.
Let me just say that the TCU training instrument that I spoke about is at no cost, because the coordinator that we have is trained to administer it. And so it's a good benefit to the people going through family court.
Thank you, Judge. Jackie?
May I talk from back here because I can't get up there?
You have a big mouth. I hear you.
I can't talk loud.
Wait a minute, we're going to have the our film director here.
Well, it's not
Want your direction?
really a major thing that I'm
Go ahead, Jackie.
Just speak loud. Just speak loud. Speak loud. My question is, and I can't hear very well, ordinarily I can't hear very well, and I really can't hear from the mic. But my question is, if a person needs a course in anger management, who can decide that that person, and will it stick, that that person needs to go to an anger management class? Is there a judge that says you are ordered to go to anger management? I mean, we all get angry, but is it in a case when it comes to children, parents can get so angry and so outdone. A child can just try their patience, but is there somebody who can order them and it will stick to go to anger management class? That's my question.
Speak right to the mic. He'll answer. Both of them will answer on that.
Trust me that I know that kids can try your patience. I also know whenever a parent would go too far because of that experience, that you better believe it. If a parent goes too far, it's the judge who can order that. It's the judge's job to protect the children, but the only way to determine how much is too far, it's again getting back to understanding that when parents do try you, in understanding how they try you, in living through it, in staying in the struggle, being patient, and then from your own experience as a parent, learning, you know what, this is over the top.
I might add, I'm not speaking for myself.
Are you sure? Are you sure? I will answer your question and tell you that the anger management that is ordered is generally for the parents, because they've been ugly and angry and vicious and vile towards each other. We don't often see violence towards the children. If there is extreme violence towards children, it's normally handled by the Department of Children and Family Services, and that becomes a juvenile case, and that would go in front of Judge Claus or Judge DePlanche. We do see some instances where someone files a ex parte order of custody because there are bruises on a child. You can't tell because a child has been bruised that there's an anger management problem. But what we do often is ask for a psychological evaluation to find out what the problem is. We also order people, again, convicted of domestic abuse, to go through what's called the DVIP program. It's the Domestic Violence Intervention Project, and that's a 12-week course. Sometimes it's successful and sometimes it's not. So all we can do as in family court is offer as many programs as we can and hope that the parents get it and recognize again that they just have to focus on their children and quit focusing on their anger with each other.
Thank you, Judge. I don't want to go too far past an hour because, you know, I don't want everyone here never to come back, because that's the worst thing you can do. But we do appreciate everyone coming here. Thank you all very much, and we appreciate you being with us.